Alright, this video lecture focuses in on chapter 13 from the book, which is the appellate process. So the appellate process is the decision to appeal a lower court's verdict decision to a higher court in the process, with eventually being the United States Supreme Court is the court of last resort. It's the highest possible court you can be appealed to. Now, most cases are never appealed. Once that trial verdict happens, the case is over, and no one moves forward with it. And so based on procedure, when you are appealing to a higher court, you need to ask them to correct something. You're asking them to fix something about the lower court. So was a legal error made? Were proper procedures followed? And were the issues not fact-based? Now, most offenders who end up appealing their case either had a bench trial or a jury trial. And in fact, many jurisdictions across the country require you to waive your right to an appeal if you decide to plead guilty. So that's one of the things that you're waiving when you do a plea bargain. You are waiving your right to an appeal. Now, if you appeal an issue to a higher court before the fact finder has made their final decision, that is called an interlocutory appeal. This is what occurs prior to the final judgment. Interlocutory appeals are allowed if the decision involves a substantial right, it involves something that would materially affect the outcome. The ruling on the appeal would affect the final decision, or it's in the interest of justice. So a prosecutor could maybe appeal the decision, a judge's decision to exclude a confession from evidence, something like that, because whether that confession is admissible or not would materially affect the fact finder's decision. And the decision that this confession be excluded also will affect the final decision. So those are the kinds of reasons when it is likely to appeal, when a prosecutor is likely to appeal. Now, for defense attorneys, they almost always appeal after the final verdict. Now, the prosecutor cannot appeal that final verdict because double jeopardy is attached. They cannot appeal and ask the court to reconsider and convict somebody. For defense, the primary issues on appeal are procedural issues and the substantive question of fairness. Did the defendant get a trial that was fair on whole? Once the appellate court gets the notice of appeal and they get the briefs and everything, they can affirm the appeal. If the appellate court affirms, they can order so the defendant alleges that they had ineffective assistance of counsel on appeal. And if the appellate court agrees and says, yes, you defendant did not have an effective attorney, they can order a new trial. And the prosecutor at that point would have to redo it. This person would get a new lawyer and they would start all over again. But the prosecutor would have the option to dismiss if they did not want to do that. There is the harmless error rule for appeals. So if an error happened during the defendant's trial, but the outcome was not affected by the error, that's called a harmless error. This was developed to prevent unnecessary retrials. It's kind of a resource-based thing. So a defendant might be able to successfully prove that a mistake was made or an error occurred, but it might not rise to the level of requiring a new trial or that the defendant be let go. Also, the appellate court can just dismiss. They can find that the defendant did not prove, they would be called a petitioner at this point, that the petitioner did not establish enough information to warrant another trial. Now, Appealing the sentence. For death penalty cases, those petitioners are entitled to an automatic appeal. In half of states, non-capital sentences can be appealed. Primarily, this is designed to reduce or prevent excessive sentences on the defendant. In the appellate courts, they all function very differently. There are usually intermediate appellate courts. Some of them only hear civil cases, some only hear criminal, some just are mixed. And then there is a state court of last resort, which is usually the state Supreme Court. So this is Arizona, but it's a little bigger. But this is what their appellate court process looks like. So you can work your way through and see kind of what happens and how they finally end up at the Supreme Court. In federal courts, the appellate courts are called circuit courts, and then the court of last resort is the Supreme Court. Again, they use that rule of 4 to decide which of those writs of certiorari they're going to accept. They usually hear under 100 cases each term, and they have a lot of discretion. This is kind of a map of the appellate court districts. As you can see, us in Indiana right here, we are in the 7th Circuit Court of Appeals. Now, do you have a right to appeal? Under due process, you have the right to have a fair trial. And one part of making sure that you have that fair trial is having the right to appeal the outcome of your case. So the Supreme Court, you preserve some right to appeal to make sure that you have the right to the case. It's not an unlimited right, though. So a prosecutor cannot appeal the outcome because of double jeopardy. Defense kind of has a limited option to appeal cases. So under this idea of the right to an appeal, so really quick, I didn't include it. So the defendant doesn't have this unlimited right to appeal, but they can appeal within so many days. They have to get it filed within the limit, and they have to have raised the issue during trial to appeal it later on. So if they want to challenge the admissibility of confession or admissibility of evidence, they need to challenge it during the trial process to preserve it for appeal later on. Once we get to the appeal, though, appellants have a few protections. You have the right to get the trial transcripts. Indigent defendants have the right to counsel as of 1963. And the government is not allowed to retaliate on an appellant for starting an appeal. All right, so that's kind of the basis of the appellate process. But there is a separate process that's really related to criminal courts in particular. This is called writs of habeas corpus. Habeas corpus kind of comes out of the Latin to mean you have the body. And these are indirect appeals. So the first types of appeals we're talking about were direct appeals about the specific case and appealing that up. Writs of habeas corpus challenge confinement. They are alleging that they are being held and they should not be. This comes to us from England. And under this post-conviction review through habeas corpus, only incarcerated offenders can file a writ of habeas corpus to be brought before the court. We almost always are going to you have a constitutional right to raise the writ and have it reviewed. But that right does not mean that you're going to get a hearing on your writ. So if the court reviews your writ and says, no, legally everything is fine here, they don't have to give you a hearing. If they read the writ and they find problems, then they have the discretion to give you a hearing on the issues in your writ. So this is because these are collateral. This is also because writs of habeas corpus need to raise constitutional questions, and they discuss different issues such as confinement-based issues. Indigent defenders are not given an attorney for these, and one last requirement is that petitioners for writs of habeas corpus need to exhaust all of their direct appeal options before they are permitted to start a writ of habeas corpus. We have seen a ton of changing and restricting. Under Warren, the Warren Court, habeas corpus got bigger, it was expanded. Under the Rehnquist Court, it kind of was restricted. The Rehnquist Court was the court before the current Supreme Court under Chief Justice Roberts. And there's generally been a lot of deference to states. So you can see kind of a plot of how many writs are filed per thousand state prisoners through the years. Now, so two different processes, appellate process, writ of habeas corpus. But let's talk a little bit about how those appellate courts make their decisions. This is a group decision-making process. There's usually going to be between anywhere from 3 to 9-ish judges that might hear a case, sometimes up to 15 or 18, but usually between 3 and 9. The minimum is almost always 3. Once that appeal is filed, the appellate courts review the transcripts and the briefs. They might request an oral argument, and then they get to make their decision. And in the decision, they write majority opinions. This is the final outcome of that appeal, which could be appealed or could not. And judges who don't agree with that outcome can write a dissenting opinion, which explains why they don't agree. So, again, we covered a decent amount of information. This chapter in your book is really good. It's really clear. Also, feel free to reach out with any questions or concerns that you have.